Good morning, Your Honors. Counsel, would you please join us on video? Thank you. The Court of Appeals is now in session.
Good morning and welcome to the Court of Appeals today, our virtual courtroom. I know that both counsel have appeared before in this virtual setting, and so we look forward to hearing your arguments today. We are hearing arguments in the matter of Bowers versus Burkhart. And counsel, if you would please enter your appearances for the record.
Good morning, Your Honor. Sarah Frommer appearing on behalf of Rachel Bowers, the appellant.
Good morning, Your Honors. Taylor Webb appearing on behalf of FLE Dustin Burkhart.
Thank you both. I know, like I said, I know you're both familiar with the way the clock works and the way that that we will mute our microphones and just try and get your attention if we have a question. I just will remind you that for our benefit, it helps, and for the bandwidth benefit, it helps for the counsel who is not arguing to turn off your camera and mute your microphone while your opponent is arguing. That just helps everybody. It appears, Ms. Frommer, that you have reserved 3 minutes for rebuttal. Is that correct?
It is, Your Honor.
Perfect. Do either of you have any questions before we begin?
No, Your Honor.
And great. And so then, Ms. Frommer, please begin when you're ready.
Thank you. Good morning, Your Honors, and may it please the court. This case is about the issue of the circumstances under which a court may order a minor child's name changed. And I would like to start off by referring the court to a quotation from Canby, which is a Utah state case that was ahead of its time in 1989. And one of the overarching instructions in Canby was that the court should not, and this is a quote, give lip service to the best interest of the child. Lip service to the best interest of the child shall not be used as a subterfuge to nevertheless perpetrate the paternal preference. And it is our position that in this case, that's exactly what the court did. It uses the words best interest, but in fact, there is zero evidence in the record really to support the conclusion that it would be in this child's best interest for her name to be changed from her mother's name, Bowers, to her father's name, to her biological father's name, Burkhart. Yes, Sean.
Yeah, can I start with a question on that? You mentioned the word evidence, and this is one of the things about this case that I'm struggling with. Your client filed an affidavit below, so that's clearly fair game. Mr. Burkhart never filed anything that was called an affidavit, but he did file a motion and a reply. And on both of them, he had a section that was called an authentication section, and he signs it and he declares under penalty of criminal law that everything in it is true. And so I'm trying to figure out, do we treat his motion and his reply as effectively or functionally being affidavits, or do we not?
Well, that's an interesting question. And I actually was researching this hastily this morning when I was preparing. And I have heard from others that the court does distinguish between authentication of pleadings and affidavits, requires affidavits to be evidentiary. I have not been able to find a case that says that. But whether the document that was filed, the response that was authenticated under penalty of perjury constitutes evidence or not, it doesn't actually have any evidence in it. It doesn't set forth any facts that demonstrate anything to support the contention that this child would be better off with Dustin Burkhart's last name. And yes, Sean.
It occurs to me that there's a fundamental difference between authentication and verification, and captioning the thing authentication goes one direction. But if there was, as Judge Kenny just said, express invocation of penalties of perjury or appropriate penalties under the criminal law, it seems like there is an attempt at least to have that treated more like a verified statement. But you're right, to the extent that legal arguments are mixed up with it, I mean, that's not appropriately authenticated or verified. Make your argument, here's your memo, move on. But I suppose to the extent that there are factual statements in there and an effort made to verify those under penalty of perjury, never mind the miscaptioning of authentication, that perhaps those should be accorded the same kind of weight that an affidavit would. Sorry that that's not a question, but perhaps you could respond to that assessment.
I think that there's a good reason not to. When somebody files an affidavit, it's in a way it's a stake in the ground or a line in the sand. When somebody files an affidavit, they are saying, this is the evidence on which I intend to rely to support my contentions. When somebody just files a motion or another document or another pleading that slaps a verification or authentication or something on the end of it, it is not stating clearly that this is the evidence on which I intend to rely. And of course, in this case, there was no evidence taken at the hearing, which only lasted for a half an hour. The only thing that the court actually heard were arguments of counsel, and relatively brief arguments of counsel at that. So to the extent that anything in the authenticated or verified pleading is considered evidence, there's no way to test its credibility, because the testimony was not, the testifying party was not, did not present any evidence in court.
Would be true of the declaration filed by your client, though. I mean, she did file a declaration, so it purports to be something akin to an affidavit, but we would have the same problem that you just identified with respect to her claims, right?
I'm sorry, could you say that again? You broke up
Yeah.
just a little bit in your
Sorry, but I mean, we would have the same problems with respect to her declaration that we would have with respect to his that you just identified, which is that she then got on stand, so there's no way to test the credibility or the veracity of what she puts forward.
Exactly, but it wasn't Rachel Bauer's burden to demonstrate that her choice was correct. It was Justin Burkhart's burden to demonstrate that the change would be appropriate. So if you don't afford her statements evidentiary weight, or you don't, or you dismiss them because of lack of credibility, that doesn't solve the problem in this case, which is that Mr. Burkhart's statements, such as they are, should be accorded the same lack of weight. And you know, this is an order of the court that is very long on speculation and very short on factual findings. I'd like to draw the court's attention. I'd like to start and focus on paragraph 12 of the court's order, because that is relevant to a couple of the key issues that led to the court's conclusion. This is the paragraph in which the court says, it starts out by saying it applies no assumption, and then it proceeds to apply an assumption. But it says the court applies no assumption whether there is a misogynistic bias. The court recognizes the cultural norm in the United States and around the world that children bear a paternal surname. Well, that wasn't even necessarily true in 1989 when Hamby was decided, and it's definitely not true now. And it says the fact is relevant here only so far as the practice of giving the minor child their father's last name is the norm in this child's family. And then it goes on to say, petitioner has given her other minor children their father's names, and not doing so with this child may cause difficulty. You will note in the court's order, every single one of the court's rulings is may, could, might, maybe. Those are not actual findings that it will or even could. Yes, Your Honor.
Can I take you to a different factor that I seems to me drives the court's analysis, which is this the custodial nature and the non-custodial nature here. Here's what I understand Judge Lund to have been saying, that because Ms. Bowers already has custody, having the child share her name is not really going to mean much to the child. But because he doesn't have custody, Mr. Burkhart, giving the child his name will then act as something of a connection and will improve that connection. And so what I think Judge Lund is saying is that there might be a marginal benefit to Ms. Bauer's relationship with the child, but there's going to be a substantial benefit to Mr. Burkhart's relationship with the child. And since it's in the interest of the child to have a good relationship with both, this comes out in his favor. Why is Judge Lund wrong about that?
Well, because there's no evidence that giving the child his name will increase their bond. And in fact, one of the things he argues, and he argues, or he even sets forth in his motion for name change, he says, respondent has no other minor children and feels very strongly that the minor child should have his name. This is the minor child as a symbol of him, not that it would be in her interest to have his name. And it's also interesting, I noticed this as I was preparing for this argument, and we mentioned it in passing in the briefing, but perhaps we should have paid more attention to it. One of Dustin Burkhart's arguments is that Rachel Bowers has interfered and won't not supported his bond and so forth. So if you give her declaration evidentiary weight, he left. He was gone. He wasn't there for her whole pregnancy. He wasn't there for the birth. According to her, he said, I hope you miscarry. I don't want to have anything to do with this child. And so when he popped up 6 months after the child's birth and said, oh, now I want to be involved, she naturally reacted in a, wait a second, I'm not sure this is such a good idea. I need some safety factors here. But the part that's missing is a week before he filed this motion for the name change, the parties agreed to a stipulated amended divorce decree in which Rachel Bowers agreed to joint legal custody. She agreed to substantial visitation, consistent with the Utah statutory scheme for such a young child. She agreed that Dustin Burkhart could have access to the records, and in every other respect, it looks like an ordinary, agreed upon decree between two parties who are both going to support each other's relationship with this child. And he didn't even give it 1 week. I see your hand.
Yeah.
Let me finish my sentence. He didn't even give it 1 week to see if that would work. He goes right in and files this petition saying, this is my only child, and I want this child to have my name because I might not have another child. And that is the child is symbol of the father that has been expressly disavowed by Handy, and in a number of cases from other jurisdictions that we cited in our brief.
And I guess my question about all of that is, what do we do with that? I mean, there is certainly information in the record that is very suggestive, right? That, we can maybe make some speculation as well, but the district court did not deal with the history of this matter and the events in the past. And so what are we to do with that fact?
That's an interesting question, Your Honor. One of our positions, of course, is that because the court didn't make any findings about whether there was in fact interference with the custody, whether there was any justification in Dustin Bowers' concern that Rachel would interfere with the custody, the court made no findings with respect to that. And as a result, and those sorts of findings, we would argue, are essential to support the legal conclusion that it would be in this child's best interest to bear her father's name to continue the bond. And because the court didn't make any of those findings, its order is quite simply inadequately supported by evidence in the record. And I think, one second, I think if there is evidence in the record that the trial court didn't rely on, I don't know that it's this court's job to go through. As a matter of fact, I think in a number of cases, this court has said it's not our job to go back through the record and find that some justification if the trial court itself did not rely on it. Yes, Your Honor.
You have suggested that quoting the old case that you did at the beginning of your argument, that um, there may be an unspoken, outdated paternalistic preference raising its head in this matter. And I guess, other than to be concerned about that possibility, that's not a basis for the decision. So there's nothing we can do about it per se, but there are a couple of aspects of the trial court's articulated bases for its decision that seem sort of consistent with that, and I'd like your take on that, and we'll be interested in opposing counsel's views as well. And those points are: number one, if the child has the same name as its mother, there may well be a concern about legitimacy. And then secondly, in this household, the custom is the children bear the name of their respective fathers. Two last names in one case, one last name in the other case, none of which is the mother's surname. And we really ought to continue within the home that custom of children having their father's name. What would you say? How should we evaluate both of those two articulated factors that Judge Lund identified: illegitimacy, paternal preference?
Yes, I think with respect to the illegitimacy finding, there is zero evidence in the record that anyone has ever suggested that this child is illegitimate because she bears her mother's name. And in fact, in this day and age, children have all different names. They might have two moms, they might have two dads, they might have, they might be adopted, they might have all different kinds of names. And I don't think in this day and age, anyone anymore would ever look at a child that bears her mother's name and conclude, oh, well, she must be illegitimate. That's just simply not a conclusion that follows. And if that's going to be the rationale, there should be some evidence in the record that somebody, in fact, raised the issue that this child was illegitimate based on the fact that she had her mother's name. That's my response to the illegitimacy. There's the same as my response to many of these questions. There is no evidence in the record to support a conclusion that anyone is concerned about the legitimacy other than Judge Lund. The finding with respect to the way that other children were named is likewise, and that was where I was going with the paragraph 12, because it bears on the Judge Lund's finding that the mother was contrarian because she did something different than she had done with her other children. The problem is there is zero evidence in the record about why she named the children of the other marriages the way she named them. If the child is of a marriage and the father is there and they're a family, then that would be a reason to name the child in the father because it's part of the family unit. We don't know why she named her children after their fathers in the other marriages, and plus which it's perhaps her thinking has now evolved. I mean, she now has a girl child, and it's a child that she was pregnant with by herself. That the father left, it was gone. Whatever, they have differing accounts of the reasons for that, but the one thing they both agree on is that he wasn't there, and she wants her girl child to bear her maternal courage and valor and Purple Heart and her maternal side's family of bravery and patriotism. And she had legitimate and positive reasons for wanting her daughter to have her name. And the fact that the children from the other marriages were named after their father doesn't indicate that like I said, there's no evidence in the record as to why that happened. So the conclusion that she's doing it differently than she did before requires a determination that the circumstances are the same. And only if the circumstances are the same can you conclude that she is deviating from standard practice. And there is no evidence that the circumstances are the same. Indeed, to the extent that we can discern evidence, it would seem that that the circumstances were different, and that the other children were born into intact families with the father present, and there was a subsequent divorce in this marriage. In the case of this child, was born to a broken marriage. The child was born after the divorce had been entered. And so, like I said, to the extent that we can discern factual circumstances from things in the record, that would indicate that the circumstances were very different between the naming of the prior children and the naming of this one. Does that adequately respond to your question, Your Honor? Yes.
Thank you, Ms. Brommer. We
All right,
appreciate
I see my time is up. If there are no further questions, I will mute and turn off.
Thank you. Ms. Webb?
Good morning, Your Honors. Taylor Webb on behalf of appellee Dustin Burkhart. I'd just like to start briefly by giving this court a cite to Pentecost v. Harward 699 P. 2nd 696. And in that case, the Supreme Court stated that a verified pleading made under oath and meeting the requirements for affidavits established in Rule 56E of the Utah Rules of Civil Procedure can be the equivalent of an affidavit for purposes of a motion for summary judgment. It's important to note that we're not on summary judgment only because the importance of that is that we're not making any presumptions in favor of the non-moving party, but it satisfies the standard for summary judgment, and so we can consider that as evidence. Yes, Your Honor.
Correct me if I'm wrong, but I thought Pentecost was talking about a verified complaint, though. And
it just says verified pleading. It doesn't distinguish between complaint.
right. I mean, I have in my notes, and it was early when I was making them, but I have it on page 697 of Pentecost that it was talking in that case about a verified complaint. And I wonder if there's a difference in that respect between a verified complaint and a verified motion, because in a complaint, you're making a lot of allegations that would be inherently factual. This person did this thing to me, which is why I'm suing them. Whereas in a motion, it's more likely going to be legal.
Sure.
And so I'm wondering if I don't know. This is not a gotcha question, because what does Ms. Farmer sense that this is very unsettled.
Right.
I was wondering as I was looking at Pentecost if that's a difference that matters there.
The court doesn't identify the difference. At 698, the direct quote is a verified pleading, so it doesn't identify a distinction that would be apparently relevant to our situation. But I think oh, yes, Your Honor, sorry.
But the rules of civil procedure do, however, enlighten that question. And I'm drawing a blank now. One of the single-digit rules of civil procedure defines pleading specifically as a complaint, an answer, a counterclaim, a cross-claim, a reply to a counterclaim denominated as such, period. There's no mention in the definition of pleading that this will also somehow include motions and memoranda and such. Pleading is a term of art, and I think, to Judge Tenney's point, pleading is unique in that those are you're going to have a prayer for relief at the end, but those are mostly factual allegations. And in a motion and a supporting memorandum, you might throw out a fact or two, but the main point is legal argument. So I think something that's not defined as a pleading in our rules of civil procedure is not something necessarily that one can verify.
That's a fair point, Your Honor, and it may be that this is actually an undecided question, but I don't think that it ultimately matters for purposes of this case, because ultimately what was discussed in the pleadings or the motions, I should say, to be accurate, what was discussed was largely the history of the parties, which the district court expressly made no findings on. And I think it's important to understand exactly what facts the district court was operating from. The district court was operating from a set of undisputed facts and a relatively small set of facts. Those facts are that Ms. Bowers has sole physical custody, Mr. Burkhart has statutory minimum parent time, and Ms. Bowers has 4 other children who all have their father's surname, and that the child is too young to have a preference. Those are really the only relevant facts, and those are undisputed facts. And those are the facts that the district court had before it to weigh. And the district court weighed those facts and determined that it was in the best interest of the child for the child's name to be changed to Burkhart. And to come to that conclusion, the district court, in the district court's words, it is in the minor child's best interest if both parents are involved in her life, and whatever ruling that will most likely help both parties be invested is what this court finds to be most significant in its determination. And that's why the district court found that granting Mr. Burkhart's name to the child was most likely to produce that effect. That's record 313. The district court identified the key factor in this case as the second factor in the Hamby factor list, which is the effect of the name change on the development and preservation of the child's relationship with each parent. Yes, Your Honor.
Oh, sorry, just Christensen Forrester. You wanted to go first. Okay, I'll go first. Okay, going to which is why I think you were going, the second Hamby factor. This is what I'm struggling with on our analysis of that factor. If we start with the assumption that the child sharing a name with one of the parents is going to improve the relationship with that parent, which seems to be the assumption that's driving a lot of this, then it seems like that factor becomes something of a nullity in my mind, unless you're willing to say that we're going to favor one parent over the other. Because if it's going to benefit his relationship with the child to have the child share his name, then it seems like it would also benefit mom's relationship with the child to share the mom's last name. And so at some level, it seems like what that second Hamby factor is asking a court to do is say, which of the parents do I want to improve the relationship most? And I'm struggling with why we as a court of appeals would say, yeah, as a matter of law, a district court gets to favor one parent over the other. Help me with that, because I'm kind of on that, on both sides.
Yes, Your Honor. I mean, I think it's important to note at the outset that that is the test that this court has set forth, and Ms. Bowers has not asked this court to either abandon or modify that test, so she needs to operate within the test that this court has set out. But I don't think that it actually does ask you to favor one parent over the other. I think this test is specifically designed to be very broad to accommodate a wide range of factual scenarios that are necessarily going to arise in family law scenarios. And if you look at all of the case law, you can see sort of how that plays out, that even one small change in the facts can make a massive difference in how these factors weigh against each other. And so
just coming to this case, though, the effect of it is to favor one or the other, because if it's going to help his relationship with the kid, then mom's response is, well, it would help my relationship with the kid too, so why don't I get that benefit? And Judge Lund's response seems to be, because you, Mr. Barker, need it more, which seems to be favoring him. And I that's the part I'm stuck on. Well, why would the law even do that? Why is that factor even a factor? Is kind of what I'm asking.
Well, I think it's significant in this case particularly because, one, the daughter is not old enough to give her preference. So for example, if you had a case where the child is old enough to give their preference, that factor then becomes effectively dispositive. But here you have the scenario where you have one parent, the custodial parent has sole physical custody. The non-custodial parent has only statutory minimum parent time, and the non-custodial parent is the one bringing the petition. And under that particular set of facts, this factor, absent some other evidence, becomes nearly dispositive just because of the way that fact affects the nature of the relationship.
All right, so let me ask the follow-up, and then I'll stop. Probably. But if we said the thing that you just said, which is what Judge Lund said, then wouldn't we effectively be writing into law a presumption that the non-custodial parent gets the name? Because that's what that sounds like.
I don't think it's a presumption, because I think you're still analyzing every other factor in the same way that you would under any other factual scenario. I think it's likely that that factor is going to weigh very heavily in favor of the petitioning non-custodial parent, where the non-petitioning parent has sole physical custody. And that's because there is case law expressly recognizing the fact that the non-custodial parent is necessarily at a disadvantage in developing and preserving the relationship they have with the child. You have a child who's going to be spending 100% of their time living with the custodial parent and being around the custodial family, and where on the other side you have the non-custodial parent having effectively minimal contact in comparison to the custodial parent. And in these scenarios, both the Preston case and the Spatz case recognize that the link between the well, the non-custodial parent, being the father in this case, and the child is weak, and not having the name of the father or non-custodial parent, regardless of gender, can further weaken or sever that bond. And sorry, Your Honor, do you have a question?
You muted
done?
that.
Are you done answering? I didn't want to interrupt you.
Oh, I can be I can be ready for your question.
So maybe this is just more of a comment, but we're operating under an assumption, right? That sharing the name of the non-custodial parent will further the bond of the parent and child. And when we're talking about what is in the best interest of the child, obviously, creating a bond between parent and child is in that child's best interest. But doesn't making that assumption further perpetuate this idea that a child should have its father's name? And why not?
Oh, I'm sorry, I didn't mean to cut you off.
Oh.
I don't think it does, because we're just talking about the custody situation. The custody situation in this case happens to be that the mother has sole physical custody and the father has statutory minimum parent time. But I think the same analysis applies if you reverse the roles. And I think, again, this highlights the fact that this is even a small change in the facts can drastically alter the balance of this test. And so, I mean, I think this kind of addresses the concern that you also had, Judge Tenney, which is that, if you have this same exact set of facts, but the parents are sharing 50-50 custody, that completely changes the analysis, and it effectively makes this factor neutral, and that doesn't then weigh in favor of either party. Of course, here we have 3 remaining factors that the district court determined also weighed in Mr. Burkhart's favor, but even that small change in allocating the custody can drastically alter the analysis under the test. I mean, even if you have 60-40, 70-30 custody, it's not completely clear. It's going to change the analysis under that test. But even where you have the scenario that we do here, where it's sole physical custody on one party and statutory minimum parent time on the other side, that's not to say that it's necessarily dispositive. There's certainly evidence that you can set forth as the non-moving party to demonstrate that factor should not weigh in favor of granting the name change, or that other evidence outweighs that factor, like in Hamby. But that evidence isn't present here. And where you don't have something that's of either equal or greater weight than the weight that you give to that development and preservation of the relationship factor, it's going to be difficult to say that it's not in the child's best interest.
But what is the weight of that evidence? I mean, as the court sets out in its paragraph 9 of its order, the court finds conversely that giving the minor child respondent's surname will likely encourage, I mean, there's been no evidence presented, it doesn't seem to me, and please correct me if I'm wrong, but there's no expert testimony here. There's no, family members giving evidence that the minor child having the Mr. Burkhart's name is actually going to do anything to his bond with his daughter. So what's the evidence that the court had before it to come up with this conclusion?
I think the evidence is largely the custodial situation, and it's certainly true that either party could have produced additional evidence, but expert testimony is not required in these circumstances. So certainly having expert testimony on either side could alter the balance of the factors here, but that doesn't mean that there is insufficient evidence to support the district court's conclusion. And I think that the problem that you're identifying, Your Honor, and that Ms. Bauer seems to take issue with is that this factor in particular sort of presumes that the name has an effect. And that's the way that the test is set forth. That's the way that the factor is set forth. And so we have to operate from the presumption that the name has an effect on the relationship with the child. And here, where the custodial situation is what it is, this is sort of the only other structural thing that Mr. Burkhart has that available to him to assist him in developing the bond with his child. Yes, Your Honor.
Oh, go ahead and finish your thought. I don't want to interrupt your thought. I just wanted to get in line.
No, I think it's particularly notable just because you have the child will be spending, effectively 24/7 with the custodial parent, and for the non-custodial parent, he has his visitation. He's contributing to the extent that he can with, visitation and child support, and there's really not a whole lot else available to him. This is structurally one other avenue that's available to him that was important to him, because he wanted it to be clear that to his daughter that, look, even though I'm not around 24/7 like your mom, it doesn't mean, I'm still your father. You are still my daughter. I still love you. I still care about you. I still want to have a relationship with you. And this is one way of demonstrating that. And again, I understand that that isn't the only way to demonstrate it, but that's what this test sets forth as something that's important and helpful to that bond.
All right.
So this will sound like a rhetorical question. I don't really mean it to be, but are you quite comfortable with the observation that if this were the other way around, if Mr. Burkhart had custody of the daughter and Ms. Bowers the opportunity for mere parent time, and Ms. Bowers sought to have the child's name changed from Burkhart to Bowers, that Judge Lund would have said, well, of course, because the daughter is with the father all the time there, and therefore appreciates that bond. Ms. Bowers needs a little help, so we'll switch the child's name from Burkhart, which is on the birth certificate, to Bowers to aid the maternal bond. That strikes you as being well within the realm of possibility?
I think that's exactly what would happen. I think that Ms. Bowers has pointed to certain statements in the district court order to suggest that there's some sort of paternalistic bias, but I think that's just, these are the facts of this case. If you switch the gender of or change the gender of either one of these parties, I think the result is exactly the same. The consideration of the fact that her other children have their father's surname is not the fact that they have their father's surname. It's the fact that they all have, she's chosen one standard practice of naming her children. That standard practice happens to be giving them their father's name. If all of the children had Ms. Bowers' surname, and then she wanted now for her fifth child to have Ms. Bowers' surname as well, I think that the district court would have been pretty well obligated to have the child's name be Bowers. It's not a question of paternalism, it's a question of consistency. And the structure of this family unit is such that each child has their father's surname, and it's not a deviation from that would not be problematic for paternalistic reasons. It's for consistency's sake.
Okay, that actually leads to the question I wanted to ask you. As I've worked through this problem with the briefing and thinking about this argument, my head starts spinning when I play out all the different scenarios of custody versus non-custody and moving party versus non-moving party. You can almost break it into quadrants, and who has custody and who's the moving party, and you end up in all kinds of different places. And then you start throwing in the potential factual scenarios, and it just gets a little bit head spinning. And one of the things that has struck me as I've thought about it is I'm not totally sure that it does make sense to look at it in terms of custody, because there's such good arguments on both sides. Do you want the kid to share the name of the non-custodial parent to improve that relationship, or do you want the kid to share the name of the custodial parent because it's going to make it easier a little bit with schools and the like? And what I'm wondering if that's not the reason why the other side is pointing to the burden on the moving party instead as being the thing that drives this. Of just saying, look, let's put aside custody. Let's just say that we're going to keep stability on the child's name, and if the other parent, whether they're custodial or not, wants to change the name, they've got to show that there's a reason to change the name. Why isn't that the cleaner answer to all this that gets us past all these quadrants? Why not just do that?
Well, I mean, it's true that it is the petitioner's burden to put forth sufficient evidence to demonstrate that the name change is in the child's best interest. But I think this is just like any other scenario where there's an initial burden, but once there's been evidence that is sufficient to demonstrate to the district court that this name change would be in the child's best interest, then it does effectively shift the burden to the other side to demonstrate why that's not true. And I think that, again, whether this is is ideal or not. This is the way that the factors are set forth, and Ms. Bowers has not asked the court to change or abandon those factors. But if you look at, for example, the factor of the possibility that a different name may cause insecurity and lack of identity, the nature of the factors in some sense are structured so that you almost have to provide evidence against the against the petitioner to say why it's a bad idea for the child to have the name. But that doesn't mean that Mr. Burkhart has not satisfied his burden here by relying on the custodial situation. Yes,
but I wonder if there's a difference on that answer. No, you're totally fine. Interrupt me, it will. I wonder if there's a difference there, though, between if you're naming a child at the outset versus if you're trying to change the name. No. Because if you're naming a child at the outset, it's one question. It's what is the best name? What's the name likely to cause embarrassment? So forth and so forth. But if you're in the different scenario where child already has a name, then why isn't the question more targeted? Why isn't the question, what's the reason? Is it in the best interest to change the name, as opposed to, is it in the best interest to have this name versus that name?
Well, these factors only apply to changing the name. So these factors necessarily only come into play when you are changing the name. This doesn't apply to naming a child at the outset.
Even if there's a contested fight at the outset?
Yeah, I think there's a statutory presumption then in favor of the custodial parent in terms of naming the child at the outset, but these factors only apply when we're talking about a petition for a name change. And so regardless of how these the factors are structured the way that they are, and some of those factors, it does seem that it sort of does put the burden on the non-petitioning party to present some evidence of the harm of having the petitioning party's name. Yes, Your Honor.
But is that actually correct? And maybe this is a distinction without a difference, but the burden is on the petitioning party to show why changing the name would be in the child's best interest. In order to rebut that, Ms. Bowers doesn't have to show why changing the name would be bad for the kid. She just has to rebut that it would not be in the child's best interest. I mean, isn't giving her reasons why she used her own last name sufficient to rebut? I mean, there's no suggestion that having Bowers as the daughter's last name is going to hurt her.
No, and again, I think that just gets back to the fact that if you change any of these facts even a little bit, it can drastically alter the analysis. But the question is the question is whether, in part, whether the Bowers name would be harmful to the bond, but the district court determined that it wouldn't be harmful to the bond it's not harmful to, there's really no effect of the name on the bond with Ms. Bowers because she has the ability, unlike Mr. Burkhart, to develop and preserve the relationship with her daughter just by way of physical proximity, by way of spending, nearly 100% of the time with the daughter. The reason that it's in the child's best interest here to have the Mr. Burkhart's last name is because he is attempting to develop and preserve a relationship. He is at a disadvantage that Ms. Bowers is not, and this will assist him in developing and preserving the relationship with his daughter. And I mean, in Christensen, for example, the father's testimony on the benefit of the child having his name, the court found that was sufficient. In Hamby is an example of how Ms. Bowers could have counteracted the idea that this was going to be beneficial for the child and not harmful to her relationship with Ms. Bowers, but that evidence wasn't present here. And I think, again, it's important to note that, you court may well have viewed this same exact evidence and come to a different conclusion, but that's not the standard of review that we're operating under. This is an abuse of discretion standard, and Ms. Bowers has not identified any problems or any suggestion that the court abused its discretion in weighing these factors. Her problem. Sorry. Yes.
Is it an abuse of discretion or is it a review for clear error? I thought the best interest determination was a factual determination. So
it's.
I know there's a little fuzziness in the briefing on this,
but to be quite honest, Your Honor, it's a little bit confusing given the statement about how you review evidence when it consists of proffers. The language of this court we have this in the response brief as well, but it's a clearly this court is reviewing the district court's findings under a clearly erroneous standard, but where the evidence consists of proffers, the court reviews the facts and draws its own legal conclusions and will reverse only where you have a definite and firm conviction that a mistake has been made. Quite frankly, it's not exactly clear to me what work that differentiation is doing, because this court has also articulated that the way we determine whether factual findings are clearly erroneous is if you have a firm and definite conviction that a mistake has been made.
And to be fair, both sides have approached the standard review, I thought, in the briefing in similar terms, where you both quoted that same language, but then you've both, I think, spoken of it in somewhat discretionary terms. And I think I know why, because it feels like this is a discretionary determination, but then it also feels like our case law has referred to it as a factual determination. And I'm not totally sure what to do with that either, but
I have the same struggle that you do, Your Honor, quite frankly, but I think that the reality is that we're operating off of a set of undisputed facts, and Ms. Bowers has not challenged any of the, the factual determinations, which are really just, the custodial situation and the fact that her other children have their father's surname. The best interest determination is phrased in terms of a factual determination, but regardless of whether you're analyzing it under a clearly erroneous standard or an abuse of discretion standard, it is not reviewed de novo. And so Ms. Bowers has not identified anything that the district court did that was clearly erroneous or an abuse of discretion. And so either way, Ms. Bowers has not demonstrated that the district court abused its discretion or clearly erred. If there are no further questions, I see that my time has long expired, so I will submit. Thank you, Your Honors.
We kept you way longer, and thank you for your arguments. Ms. Brommer.
Yes, I'd like to start off by challenging the assertion that we have not argued that the court abuses discretion. We didn't argue it in terms of abuses discretion per se, but what we did say is that there's no evidence in the record. There are no facts in evidence that support the court's decision, and therefore the court's decision is purely speculative. And this court is as capable of making speculations as the district court is speculation.
Because I understood Ms. Webb's response to that to be, no, you don't have to speculate, because the key procedural facts are what are driving it. The fact that she has custody, he doesn't, and from that you can draw a lot of their argument just from that alone. So that wouldn't be speculative.
Yeah, well, Your Honor, that argument, as Your Honor's identified in response to Ms. Webb's arguments, is equivalent to a presumption in favor of the non-custodial parent. And there's nothing in the law that says a non-custodial parent gets some sort of presumption. In fact, in virtually every case involving a child under the age of 5, the way the parent-time statute works is that children under the age of 5, that the shared custody for children under the age of 5 is more in favor of the primary custodial parent, and the stipulation increases the custodial time when the child turns 2 and increases it again when the child turns 5. And if Mr. Bowers has, if Mr. Burkhart has earned the right to more visitation and at some point wants to ask to have it shared 50-50, then he can certainly make a motion to modify the parent time at the appropriate time. But I go back to the point I made, is that the court determined that it would benefit the relationship, and that for this child to have her father's name without any showing that there was any detriment to the child's relationship with her father, because she didn't have the father's name. In fact, the father waited exactly 1 week between a stipulation that expanded his custodial rights and the time he insisted that he be that the child bear his last name. And so therefore it is a pure speculation that changing the name will improve the bond. And as many of the cases say, the way you improve your bond with your children is through your parenting skills, not through naming privileges. And he's essentially saying, well, give me naming privileges and I'll be a better dad. That's not something I think this court wants to encourage either, because then it becomes a bargaining chip, and since in contested divorces, you know, who gets to name the child. I'll be the better parent. I'll be the better parent. Let me have the name. And that's not I don't think that's the kind of policy that this court should be encouraging. Now, and you know, I'll stop with that. Our position is that there is no that the court's decision to award Justin Burkhart his request that the child bear his name is based on purely speculative analysis by the court of by the district court. There is no evidence in the record to support this conclusion. The fact that her other children bear their father's names is not dispositive because there's no evidence as to why that's the case. But second of all, they bear 3 different names. They don't all have the same name. And so to the extent that there's confusion or misunderstanding, you know, they already have that problem. That's the problem in today's modern family. Children may have all different kinds of names. And the you know, the notion that having one name as opposed to the other implies that you're illegitimate or that you're not loved or that the person isn't the real parent or any of those things, those are so outdated and antiquated that one can only conclude that there was a preference in favor of the father and the maternal surname, which is, and according to Seth, there's a tough cultural norm in favor of the paternal surname, even though I'm applying no assumption. But it wasn't, even in 1989, when this court decided Hamby, they already recognized that it's not appropriate to have a presumption of paternal versus maternal surnames. And to the extent that that was a correct and appropriate decision, you know, 35 years ago, it's even more true now. And the fact that Justin Burkhart did not even attempt to use the tools that he had been given to form a relationship with his child before he concluded that the name was the problem is underscores the fact that he's doing this because he wants it as a symbol of his paternity and not because it is in the child's best interest. And the court's conclusion that it would be in the child's best interest is pure speculation, and emotion has to be supported by evidence. And by the way, Judge Orm, I agree with your interpretation that pleadings are a term of art and is defined by the rule. And we informally call other documents pleadings, but they're really not pleadings. And I will stick with my original response that the reason you have an affidavit sworn under penalty of perjury is it draws a stake, you know, it puts a stake in the ground. This is the evidence I'm trying to rely, as opposed to the arguments that I am making. So if the court has no further questions, I will rest my case.
Thank you, Ms. Brommer. Ms. Webb, I'll ask you to return. Thank you. Thank you both for your arguments today. This is a very interesting issue, and it's your arguments were very helpful, so thank you. We will take this matter under advisement and render a written decision as soon as we can. Appreciate you being here today, and we hope to see you in person soon. Thank you so much. We'll be in recess.
And thank you, Your Honor.